Counsel, before we begin, as I see Mr. Hickson here, I'm reminded that I should make a disclosure. 7 or 8 years ago, Mr. Hickson, I'm not sure of the time, he was a Stetson student. I was a judge in the Sixth Circuit. He was assigned to me as an intern through the Stetson intern program. It's not a recusal basis. I just thought I should make the disclosure. And he didn't file a brief, so I really didn't catch it until I saw him in the courtroom. Okay?
Thank you.
Any objection to me presiding in this case?
No, Your Honor.
Thank you.
The only objection I have is that Mr. Hickson didn't file a brief. I've never been faced with the prospect of having to argue against somebody that hasn't given me notice of what their arguments are going to be. So I contacted Mr. Hickson 2 weeks ago, I want to say, and then as recently as Monday we had contact. We never talked. It was email contact, but I was not aware he would even be here. So I'm going to object to him being allowed to argue because I don't have any notice of what he's going to argue. However, I will make my argument on behalf of Isabel Wetz. I'm Stephen Kervin from Sarasota. Isabel Wetz is here in the courtroom observing. She is the appellant. She owns a house in Manatee County. She and her husband, Patrick Hall, who is a defendant as well and been defaulted. We're not sure where he is. We have reports he's either been deported or he's in Sebring, whatever. We did get service on him, and there's a cross-claim by her regarding the issues between she and her husband as it relates to her contribution to the house and partition issues and that kind of thing. But the action was tried before Judge Gallen on the Wells Fargo issue that the mortgage was in default. We had defended on the basis that she had reached a modification agreement verbally with them, and she was there to testify. The judge surprised me when he said she's not going to be allowed to testify, and I said to the judge, Your Honor, she's entitled. She's on the mortgage. She's an indispensable party to a mortgage foreclosure action. I think the cases are, beyond question on that. But he said, no, she didn't sign the note. There's no personal liability here. She's not going to be allowed to testify as to the modification of this mortgage. So I made a proffer, basically saying that Isabel Wetz had a cross-claim pending. The judge said, well, that should be in family court. So I then continued with the proffer by saying that Isabel Wetz and her husband, Patrick Hall, had purchased this home for $405,000, that Isabel Wetz had $200,000 of her money in this house, and that the mortgage, which was under foreclosure that we were there on, was $205,000, and she certainly had an interest in the property. She certainly had an interest in calling the bank and attempting to reach some modification, some, whatever you want to call it, an accord to hang on to her home. As it was, the judge's ruling precluded her from even presenting testimony to attempt to convince the court that she should be allowed to keep the home. And of course, we all know the mortgage foreclosure action is equitable in nature. And so obviously a person entitled, as I pointed out to the judge, well, judge, if she's not allowed to testify and she's not considered as a party in this case, then they're not going to get good title. And that's the reason they joined her. So I'm suggesting to this court to preclude her from testifying is to deny her property interest and is a basic denial of due process.
One concern I have, Mr. Kervin, is the proffer that was made to the trial court is fairly lacking in details as to what she would have testified to. You indicate she intends to testify that she got an agreement with them to reduce the amount of the mortgage, and we have documents to present to that effect. I'm not certain exactly what an agreement to reduce the amount might be, but there's no representation or proffer that the bank agreed to hold off or the bank agreed to modify with her taking over as the debtor. I mean, there's just a real lack of detail, which is troubling to me.
It was troubling to me too, Your Honor, because basically there were like 50 cases set for trial in one day. I was given about, and it says right in the record, we have 1 minute or 2 minutes. I've forgotten what the time is. Basically, they were allowed to testify that there was a note in mortgage and that it was in default, and I was not allowed to testify anything. I did make a rather abbreviated proffer simply because I didn't think I had any time to do anything. But in that proffer, I mentioned the fact that she's got a cross-claim pending. I mentioned the pleadings. And I also would point out to you, Judge, there's a disclosure to the other side of documents And document number one, exhibit number one, intended to be introduced into evidence, is Isabel Wett's notes as to many, many, many phone conversations, including...
But we don't know that.
Well, Judge Gallen knew it because it was there in front of the court. I was being told, you can't talk.
Well, Mr. Kervin, why didn't you cross-examine the bank's witness?
Cross-examine him as to what?
As to whether they modified the loan, or whether they agreed to abate it, or hold off, or anything. You didn't ask him one question about that at all. You simply contested his, whether he was a proper records custodian or not.
I disagree with your conclusion, Judge Sleet. I asked the court for permission to examine the witness, and I established that he had had this file. He had no knowledge of this file within the week before this trial. So it's impossible for him to have any knowledge about anything relating to her conversations with the bank.
But you didn't ask that question so that we could see the answer, that he didn't. You didn't ask the question.
I believe I did.
That's your supposition. You didn't ask him any questions about whether Ms. Wetz had modified this loan or not.
Well, at that point in time, I wasn't aware that I was not going to allow her to testify.
Well, they had
When I was questioning the bank's witness, it was the case in chief for the bank. When I was allowed to present a witness, I asked to call Isabel Wetz, and the judge said I'm not going to allow her to testify.
Well, but you don't disagree that Mr. Hall was the only one that signed the note.
I do not.
And you
I do not disagree with it.
Well, you don't disagree that there was competent substantial evidence that the note was in default, and the bank had standing to foreclose.
That was the reason that she was trying to make the arrangements with the
So
bank.
then, what, if any, legal defense is it on the part of Ms. Wetz, who didn't sign the note? What, if any, legal defense is it whether she's negotiating to modify it or not?
She has an equitable defense, which is she has $200,000 in cash in the house that she's attempting to preserve, that she will lose when the foreclosure occurs, and that she was entitled, and they had to make her a party. Now, I've never heard of such a conclusion that a party, an indispensable party to a cause of action, can't testify in her own defense. And the question I think you're asking me, Your Honor, is that relevant to this case? And the answer is certainly it's relevant.
This is marital property, correct? This was the marital home.
It was, and that's what the cross-claim was about.
And you would agree that this could be partitioned, and any payments that she may have paid toward this home could be settled within an equitable distribution scheme?
What I was prevented from doing, Your Honor, was, one, defending the foreclosure action, and two, coming back on the cross-claim, which we were going to testify as to, and say, I have all of the money in this house other than the mortgage money that's owed. And if I'm allowed to modify the mortgage, as they agreed to do, then she will own the house, exclusive of Patrick Hall's interest. I was attempting to get to that conclusion. I was not allowed to even present evidence.
But the logical extent of your conclusion, and had she been able to testify, would simply mean the bank would have trouble selling the home.
No. With all due respect, Judge Sleet, I think what I'm trying to say is, Judge, you have to hear the entire circumstances of this case before you can take this house away from her. And instead of that, he said, you didn't sign the note, you can't testify. And I do thousands of real estate transactions. There are many times when for some reason or other the bank doesn't want one spouse or the other on the note. They want the credit of the one. But that particular spouse who doesn't sign the note must sign the mortgage because they're on the deed. And without it, you don't have a valid foreclosure action. You don't get good title. So I'm suggesting to you the logic that I'm using is Isabel Wetz is an indispensable party. Isabel Wetz has a substantial equity in this property. The bank has asserted the equitable powers of the court to take it away from her. She's simply saying, let me tell you what has happened here between Wells Fargo and my husband. And the court said, no, you're not allowed to testify because you didn't sign the note.
Later on, after the bank presents its case, the court indicates, you say, I'd like to present the defendant's case, and the court says, well, you can proffer it, but as I said, her only interest is the property owner, no personal obligation. And then you and the court get into a short dialogue. Ultimately, you say she was attempting to modify the debt as an agent of her husband. She was speaking for both of them. At that point, the proffer is, we haven't reached a modification, but we're trying. And so, again, I'm very troubled by the lack of information in the proffer as to what she would have testified that would have precluded foreclosure.
I'm not recalling the exact language, Judge Silverman, but I in no way intended nor believed that she was attempting a modification. We had an exhibit in front of us.
This is what the court reporter took down. Mr. Curvin, that's true. And she was attempting to modify the debt as an agent of her husband. She was speaking for both of them. And then the court says, I'll overrule that, I'll grant judgment for the plaintiff.
Well, I understand, but as I just was explaining to Judge Sleet, I think we're taking a microscope to what is a very broad picture here. We have a house, we have a mortgage, we have a note, we have a deed, we have a lady who has $200,000 in cash. I'm attempting to explain to the judge that you can't just preclude her from testifying to all that because there is a mortgage foreclosure pending.
Let me follow up, Mr. Kervin, with what Judge Silberman said. Even after the judge had announced the ruling, you then requested 30 seconds to proffer any additional evidence, and the court said you are allowed to do that. And then at line 10, page 15, Isabel Wetz took title on the deed. It was her $200,000 cash that we used to purchase the house, and then, of course, she signed the mortgage, and she's trying to protect her residence and her home. That's all we have.
I don't know what more I could have said to explain it briefly. Again, maybe this isn't a valid consideration, but I'm in a courtroom one day, 50 trials, not 50 hearings, not 50 parties, 50 trials. I think it was 51 actually. And I was there all morning. At lunch, they called the witness. He has 1 week he's had this file in his hands, so there's nothing that he knows that I can elicit from him. I have my client standing there who's going to testify, and the judge said she can't testify. So I have 1 minute, as it says right in the record, Judge Sleet, I have 1 minute to tell this judge, here's why you need to let her testify. And obviously I'm proffering, so I know I'm going to be telling this court that, not him, because he's already told me, you can't have her testify. So I spend a very brief period of time telling her, this lady has ownership of this property, she has $200,000 in it, she's trying to protect this piece of property. And the judge said, you can't do it because you didn't sign the note.
But in terms of preventing the foreclosure, those representations or that testimony, had she been permitted to testify, I don't think would have stopped the judge from entering judgment unless the testimony were the bank has agreed to A, B, C, and D, and therefore they're not entitled to foreclose at this time.
That is the representation I'm making to this court, that she had a specific number they'd agreed to, and then they refused to submit it to her in writing. Then they filed a foreclosure action. That would have been the testimony. Had I been given more time, I might have been able to explain it.
Was settlement and modification raised as an affirmative defense?
Absolutely. First thing we ever did. First thing, when she told me she had $200,000 in this property, I said, you must be kidding.
But that's a different issue.
No, it's not. The affirmative defense is she was attempting to salvage her home and her $200,000, and it was raised as an affirmative defense. And when she was told you can't testify.
I don't have the affirmative defense in front of me. What is your recollection of what you pleaded as the affirmative defense relating to settlement and modification?
In essence, it was much the proffer that I'm saying wasn't made. It's basically saying that Isabel Wetz has an ownership interest in the property.
Was there an affirmative defense that says the plaintiff and this defendant have reached an agreement as follows?
Judge Silberman, I always hesitate to say something to a court that I don't clearly recall, but I'm suggesting to you.
I'm very comfortable letting you know, Mr. Herman, we will double check.
All right, good.
But I want you to be able to respond if that's what you raised.
Two affirmative defenses. Estoppel, they can't foreclose on this mortgage because they've agreed to something to the contrary. Secondly, that she has the equity interest in this property as it relates to the bank and as it related to Patrick Hall. We early on filed the cross-claim affirmative defense from the beginning. We have those affirmative defenses. Apparently Judge Morris has it there on the pad.
I didn't see them. I'm just showing him what I found.
You didn't find them?
I didn't see it the way you said it. But that's okay. He's going to read it.
All right.
Actually, now that Judge Morris has kindly pulled it up for me, I had read these before. The defendant is entitled to the protection of the administrative orders of the Judicial Circuit regarding mortgage foreclosures. The plaintiff has failed to comply with those and should be denied foreclosure until compliance has been documented and filed. And then the defendant is entitled to the protections of the law regarding lost notes, has not established the necessary protection as it relates to the promissory note and so forth. So unless there's an amended,
I don't remember if there's an amended answer in defense. I think when I filed the cross-claim, which was significantly later, I was attempting to find Patrick Hall. And when I couldn't find him, then we filed the cross-claim and I got service on him out in Sebring. But I believe there is an amended answer in defense. But I would go back again, Judge Silberman, and that's where I'm having difficulty, because we have a person who's in front of the court ready to present testimony as to why this foreclosure should not proceed, and she's denied. I attempted to proffer to the court what I'm suggesting here. Given the circumstances and the limited time I was provided, and the fact that all the documents speak to this, it wasn't something that the bank was not aware of. I can't believe that she is going to be denied the right to testify to defend her $200,000 in her home.
I'm trying to figure out how the court limited you, Mr. Kervin, because it was you that set a time frame on your proffer. You said, Your Honor, may I take 30 seconds? I'm looking through here. I don't see where Judge Gallen limited you to any amount of time at all for your proffer.
I've known Judge Gallen for years, and that's not his nature. I'm not suggesting that he in any way did anything but act as he should as a judge, but I'm suggesting to you, in the courtroom with 51 trials, if we take 8 hours and divide 51 into it, we have about 4 minutes each or something like that. And I was rushed. Whether I was right in doing that, I don't know. All I'm saying is I'm in a court of law, I'm talking to a judge, and I basically said, Your Honor, this lady has a lot to lose here today, and you're precluding her from even testifying? And he said, that's correct. And I said, let me at least proffer on the record why she needs to testify. And I think that she has a fundamental due process right to do so. Thank you.
Thank you.
thank you. So,
Did I
Mr.
reserve any time, Your Honor? I'm sorry, I didn't answer.
Well, there's still time on the clock, but I'm puzzled by what Mr. Hickson is doing here, so I want to hear why you're here.
I wanted to know if I had an opportunity to rebut what I was asking.
If he is allowed to argue, you'll have an opportunity to rebut.
Thank you, Your Honor.
May I approach the podium?
You may.
Thank you. Christopher Hickson on behalf of the appellee. And Your Honor, the reason why I'm here today is, one, there was a notice, and out of due respect to the court, I appeared even though I have not filed any brief in the matter. If Your Honors allowed me to say anything, I would not be arguing as to any merits of the case. I would just want to state what I do believe the standard of review is and comment no more.
Well, I think we understand the standard of review. You didn't file a brief explaining it, so do you have...
Your Honor, respectfully, I'm not able to argue, and I'm not going to attempt.
I mean, the brief was not, you're not here to tell us that the brief had been sent in and must have disappeared.
No, Your Honor, I'm not here to misrepresent anything to the court, just to be here out of respect for the court.
Thank you, Mr.
Thank
Hickson.
you.
Then there's nothing further, so we will conclude. Thank you very much.
Thank you
We are
all.
going to take a 15-minute recess, and we will then hear the last 3 cases on the docket.